Question 1. From a historical standpoint, a technology company in San Jose, facing repeated violations of California's break period laws, decides to flatten its organizational hierarchy to promote accountability at every level. As part of the restructure, HR must revise supervisory roles to ensure labor law compliance and minimize legal exposure. Which of the following is the most legally strategic action for HR? A. Eliminate mid-level managers and shift compliance responsibility to team leads. B. Require employees to waive rest and meal breaks through updated handbooks. C. Integrate compliance KPIs into job descriptions for newly defined leadership roles. D. Outsource compliance management to a third-party firm based outside California. Answer. Correct answer. C. Explanation. Under California law, wage orders and Labor Code SS.7, employers cannot allow waivers of rest meal breaks and remain liable for penalties. Shifting responsibility without authority, as in team leads or outsourcing to non-California entities, risks misalignment with state requirements. Incorporating compliance accountability into job roles ensures ownership within legal bounds. Flatter org must still assign clear, compliant duties to leadership. Question 2. As a result of a recent acquisition, a Los Angeles-based firm must consolidate employee benefits across locations. Several female employees request clarification on pregnancy disability leave (PDL) benefits. What is the most accurate response an HR professional should give regarding PDL under California law? A. PDL provides up to 12 weeks of unpaid leave per pregnancy. B. PDL is only available after the employee exhausts SPHRc leave. C. PDL offers up to 4 months of job-protected leave for disability due to pregnancy. D. PDL only applies to companies with over 100 employees. Answer. Correct answer. C. Explanation. PDL under California's Government Code SS offers up to 4 months of job-protected leave for disability due to pregnancy, childbirth, or related conditions, regardless of SPHRc usage. It applies to employers with 5 or more employees, not 100 plus. PDL is independent of SPHRc and may be taken prior to or after other leaves. This makes it uniquely generous compared to HRCI standards. Question 3. Despite the fact that an HR manager in San Diego thoroughly trained staff on internal reporting procedures, an employee was retaliated against after reporting illegal wage practices. Which California regulation most directly protects the employee? A. California Civil Code SS. Punitive damages. B. California Government Code SS. Whistleblower Protection Act. C. Labor Code SS.5. Protection for employees disclosing violations. D. California Evidence Code SS. Statements in negotiations. Answer. Correct answer. C. Explanation. Labor Code SS.5 is California's primary whistleblower protection statute prohibiting retaliation against employees who disclose suspected legal violations. This applies even if the report was made internally and regardless of the employer's internal training, while SS applies to state employees. SS.5 protects private sector workers. Training is not defense to actual retaliation. Question 4. The central argument for banning certain interview questions in California revolves around fairness and equity. Which of the following interview questions would violate California's current employment law? A. Are you legally authorized to work in the United States? B. What are your long-term career goals? C. What was your salary at your previous job? D. Can you work weekends occasionally? Answer. Correct answer. C. Explanation. California Labor Code SS.3 prohibits employers from asking applicants about prior salary or relying on salary history to determine pay. This measure supports the state's commitment to pay equity and aims to prevent the perpetuation of wage disparities, especially for women and minorities. The other questions are compliant if framed appropriately. Question 5. Throughout the course of a compliance audit, a Bay Area biotech firm discovers its automated system calculates overtime based on a weekly average rather than daily hours. What consequence does this practice pose under California law? A. No issue, since weekly averaging is acceptable with employee consent. B. The system violates California labor code, risking back pay and penalties. C. Only federal law applies to overtime, so the practice is compliant. D. Overtime can be calculated monthly if bonuses are included. Answer. Correct answer. B. Explanation. California Labor Code SS mandates daily overtime. More than 8 hours a day or 40-week triggers op pay. Averaging across pay periods violates this requirement and may lead to civil penalties, employee back wages, and POGA lawsuits. Employee consent does not override statutory protections. Employers must configure systems to calculate overtime per day in like federal FLSA standards. Question 6. When faced with an increase in ergonomic injuries among remote workers, HR, a San Diego firm, considers modifying the company's injury and illness prevention program (IIP). Which action aligns best with California regulations? A. Only on-site injuries require investigation and reporting. B. Remote employees must sign waivers to exclude their home offices. C. The IIP must include remote work site assessments and training. D. Remote injuries can be handled informally without documentation. Answer. Correct answer. C. Explanation. California requires all employers to maintain a written IIP under Title 8 SRS, which must include all work sites, including remote offices. This includes identifying hazards, investigating injuries, and training employees. Waivers or informal handling violate CALOSHA rules. Remote environments are considered employer-controlled workspaces when work is assigned there. Question 7. Considering the evidence, Tanaka, a department manager at a San Francisco design studio, documents an employee's underperformance. He plans to issue final warning and terminate if improvement isn't shown. However, the employee HD and recently requested flexible schedule. What should Tanaka do to remain compliant? A. Proceed with termination since performance standards must be enforced equally. B. Deny the accommodation because it was requested after discipline began. C. Engage in an interactive process and explore reasonable accommodations. D. Require the employee to provide psychiatric testing to prove the condition. Answer. Correct answer. C. Explanation. Under California's SPHRc Code SS, employers must engage in good faith interactive process to assess reasonable accommodations for disabilities, including EHD. Even if the request comes during performance issue, the timing does not invalidate the legal requirement to accommodate unless it causes undue hardship. Demanding psychiatric tests without clear cause may violate privacy rights. Question 8. A critical examination of an HRCI system. A Santa Clara firm reveals excessive access privileges granted to non-HR staff. According to California Consumer Privacy Act, SPHRc, what is the most critical requirement for HR data access control? A. All employee data must be encrypted during transmission only. B. Employees must be notified annually about who can access their data. C. Access must be role-based and restricted to business needs. D. HR data must be stored in external servers outside California. Answer. Correct answer. C. Explanation. Under SPHRc, employers must implement role-based access control (RBAC) for personal employee information, ensuring data is only available to those with a legitimate business purpose. Encryption alone isn't sufficient if access is overly broad. Transparency is key, but so is minimizing exposure. Hosting data out of state doesn't bypass California's jurisdiction. Question 9. By evaluating his options after repeated misconduct, Aragon, an HR director in Fresno, plans to terminate an employee for violating workplace conduct policies. The employee, however, alleges the policy was not clearly communicated. What must Aragon ensure before proceeding? A. That the employee was warned in writing and signed a policy acknowledgement. B. That the employee was given 3 verbal warnings as per federal guidelines. C. That the policy was posted in all public break rooms. D. That other employees have been terminated for the same offense. Answer. Correct answer. A. Explanation. California's just cause principles, although not strictly codified for private employers, are increasingly considered in wrongful termination claims. Courts assess whether policies were clearly communicated, the employee had notice, and discipline was applied consistently. Acknowledged documentation. G. Signed handbook protects the employer. Verbal warnings or public postings are insufficient defenses alone. Question 10. Under the assumption that a Los Angeles startup pays all employees equally regardless of job duties to promote equity, what is the legal risk under California law? A. No risk, as equal pay promotes their objectives. B. High risk of wage differentials are not based on job-related factors. C. Risk only if employees complain to the labor commissioner. D. Risk only exists if men are paid more than women. Answer. Correct answer. B. Explanation. California's Equal Pay Act Labor Code SS.5 requires that wage differentials be based on bona fide factors such as skill, effort, responsibility, seniority, or geography. Paying everyone equally may disadvantage higher skilled roles and invite reverse discrimination claims. Day efforts must still be anchored in legal compensation structures, not blanket equality. Question 11. While examining a change management initiative, a large media firm in Burbank is rolling out an AI-driven performance tracking system. Employees have expressed concern over surveillance and data use. What should HR prioritize to ensure the change is compliant with California law and culturally sensitive? A. Notify employees after implementation per internal policy. B. Issue a general FAQ about AI and encourage adoption through peer mentors. C. Conduct a data impact assessment and provide privacy disclosures (PCPA). D. Reassign dissenting employees to offline roles to avoid legal issues. Answer. Correct answer. C. Explanation. Under the California Consumer Privacy Act (CPA) and CPRI, employers must conduct privacy impact assessments when using AI or automated systems that may affect employment decisions. Employees have the right to know what data is collected and how it is used. Failing to disclose tracking mechanisms or gather consent could result in state fines and employee lawsuits. Question 12. To better understand their responsibilities, an HR coordinator a Fresno food processing plant is trained on California's workers' compensation requirements. Which of the following actions would violate the law? A. Referring an injured employee to designated medical provider network (MPN). B. Denying benefits because the injury wasn't reported within 24 hours. C. Allowing modified duty while the employee recovers. D. Filing on claim form and starting benefits within required timelines. Answer. Correct answer. B. Explanation. California law. Labor Code SS allows employees 30 days to report an injury for workers' comp purposes, not 24 hours. Denying benefits due to 1 day delay violates the law and could trigger penalties and civil liability. Employers must respond promptly and offer a deadline form regardless of delay within that window. Question 13. In contrast to federal standards, a Los Angeles biotech firm seeks to reward top performers with accelerated promotion. A concern is raised about how the policy interacts with California's equal opportunity framework. What is the most legally sound step HR should take? A. Proceed with promotions based on subjective manager evaluations. B. Document performance outcomes tied to clearly defined metrics. C. Use anonymous nominations to avoid potential bias. D. Promote employees based solely on seniority to avoid legal risk. Answer. Correct answer. B. Explanation. California law, SPHRc, Gov Code SS, requires non-discriminatory employment practices. Promotion decisions must be based on objective job-related criteria. Subjective evaluations risk implicit bias. Claims seniority alone may ignore merit and performance. Documentation tied to measurable results best supports compliance and reduces exposure to disparate impact claims. Question 14. From multiple perspectives, how does California's SPHRc differ from the federal FLA in terms of coverage? A. SPHRc does not cover leave for domestic partners. B. SPHRc allows leave for adult child care even if not incapacitated. C. SPHRc includes care for grandparent or sibling, unlike FLA. D. SPHRc is only applicable to employers with more than 100 employees. Answer. Correct answer. C. Explanation. The California Family Rights Act (SPHRc) was expanded to include care for grandparents, siblings, grandchildren, and domestic partners, which are not covered under FMLA. SPHRc applies to employers with 5 or more employees, unlike FMLA's 50-employee threshold. This reflects California's progressive stance on family inclusivity in leave laws. Question 15. Taking into account a culturally diverse tech team in San Diego, HR observes a pattern of communication breakdowns tied to cultural misunderstanding. What is the most effective long-term strategy to mitigate such issues? A. Conduct mandatory training focused on workplace civility only. B. Terminate employees who cause repeated misunderstandings. C. Provide day-based conflict resolution training tailored to intercultural contexts. D. Implement zero-tolerance policies without room for explanation. Answer. Correct answer. C. Explanation. California workplaces are increasingly diverse and employers are encouraged to use informed conflict resolution models, CAL. GovCode SS. These address cultural competencies and improve communication across differences. Zero-tolerance policies or broad civility training alone fail to address root cultural misunderstandings. Termination without education fosters mistrust and legal risk. Question 16. The prevailing attitude toward HR investigations under FAIR emphasizes neutrality. An HR manager in Oakland is asked to investigate sexual harassment by a senior executive. What is the best action to maintain credibility and compliance? A. Conduct the investigation personally to show internal control. B. Use a neutral third-party investigator to ensure impartiality. C. Ask the accused to write a detailed report for self-defense. D. Wait until the complainant provides hard evidence before investigating. Answer. Correct answer. B. Explanation. Under California's Fair Employment and Housing Act, fair employers must conduct prompt, fair, and neutral investigations. Using a qualified external third-party investigator minimizes bias, especially when a senior leader is involved. Waiting for hard evidence delays compliance, and the accused should be interviewed, not asked to defend themselves in writing without context. Question 17. Across different scenarios, new hires in the San Francisco company are frequently confused by conflicting information in onboarding materials. Which of the following is a required element in California onboarding that could mitigate compliance risk? A. A signed ethics oath in front of a notary. B. A printed history of the company's founders. C. Notice to employee outlining paid sick leave and employer info. D. Checklist of federal laws employees must memorize. Answer. Correct answer. C. Explanation. California Labor Code SS.5 mandates that employers provide notice to employee upon hire detailing the rate of pay, payday, workers' comp carrier, sick leave policy, and more. This is required for non-exempt employees and must be in the employee's primary language. Lack of such notice opens the employer to penalties and labor commissioner scrutiny. Question 18. With respect to workforce analytics, a Santa Clara startup analyzes exit interview data and discovers that 80% of resignations occur within 6 months of onboarding. What is the best HR response from a strategic and compliant perspective? A. Increase probation period to 1 year and reevaluate. B. Conduct a statistical root cause analysis and review onboarding effectiveness. C. Request employees to sign a non-resignation clause for 12 months. D. Limit hiring from demographic groups with higher turnover rates. Answer. Correct answer. B. Explanation. California HR professionals should apply data-driven approaches that are compliant and equitable, analyzing turnover trends and modifying onboarding or mentoring programs based on root cause is both ethical and effective. Extending probation arbitrarily or restricting hires based on demographics may lead to discrimination claims under FAIR. Question 19. The core principles of business acumen in California HR emphasize understanding the external market. Which of the following is most critical for aligning HR with California's business environment? A. Monitoring competitors' ad budgets and copying brand language. B. Following only federal trends to simplify planning. C. Understanding demographic shifts and regional labor trends. D. Building internal systems without considering state-level influences. Answer. Correct answer. C. Explanation. California's diverse population, fluctuating cost of living, and region-specific labor markets, e.g., Silicon Valley versus Central Valley, require HR to remain attuned to local economic and demographic factors. This supports workforce planning, day, and strategic compensation. Ignoring state trends or copying branding misaligns with California-specific HR compliance and strategy. Question 20. To illustrate this point, an HR manager in Sacramento discovers that a senior leader has hired relatives into multiple roles without disclosure. This undermines transparency and staff morale. What is the most ethical and compliant step HR should take? A. Ignore the issue since the relatives are qualified. B. Discreetly remove the relatives to avoid a lawsuit. C. Escalate the conflict of interest to governance or compliance leaders. D. Publish an internal memo discouraging favoritism in general terms. Answer. Correct answer. C. Explanation. California HR professionals are held to HRCI ethical standards, which demand addressing conflicts of interest transparently. Favoritism, even if hires are qualified, can violate anti-nepotism policies and damage morale. Escalation to internal governance or legal ensures structured, legally sound resolution. Passive approaches or ignoring the issue are unethical. Question 21. The implications of Calosha's standards were made clear after an indoor warehouse in Bakersfield experienced heat-related employee hospitalization. The facility had no written heat illness plan. What should HR do to address legal liability and prevent future violations? A. Install fans and verbally instruct workers to take breaks. B. Report the incident but wait for OSHA to issue citation before acting. C. Develop written heat illness prevention plan as mandated by Calosha. D. Only require outdoor workers to be trained on heat stress protocols. Answer. Correct answer. C. Explanation. Under HRCI, all California employers, including those with indoor environments likely to exceed 82, must implement written heat illness prevention plan. This includes training, access to water, shade, and cool-down rest periods. Calosha actively enforces these standards. Verbal direction is not sufficient. Question 22. With the advent of new anti-discrimination laws, a San Diego firm is reviewing its job postings. Which revision is most aligned with California's fair employment laws? A. Looking for digital natives under 30 to join our fun team. B. Must be able to lift 50 pounds and stand all day, no exceptions. C. We encourage applicants of all backgrounds, ages, and abilities. D. Female candidates preferred to balance our male-dominated sales team. Answer. Correct answer. C. Explanation. California's Fair Employment and Housing Act, FAIR, prohibits job postings that suggest age, gender, or other protected characteristic preferences. The only legally compliant and inclusive statement is one that promotes diversity without discrimination. Statements like digital native imply age bias and are explicitly scrutinized by regulators. Question 23. Upon closer examination, a Bay Area firm is reviewing its executive compensation to ensure it doesn't trigger shareholder dissent. What is California-specific consideration HR should be aware of? A. There are no California-specific reporting rules for executive pay. B. California mandates fixed cap on executive bonuses. C. Public companies must disclose CEO pay ratios under state transparency laws. D. Only federal laws apply to executive compensation disclosure. Answer. Correct answer. C. Explanation. While the SEC mandates disclosure of EEO to median employee pay ratios, California further scrutinizes executive compensation through state-led shareholder activism, particularly under the California Public Employees Retirement System (CalPERS) guidelines. These influence public accountability. HR must ensure transparency and fairness in alignment with both state expectations and federal rules. Question 24. During the process of contract negotiations, is Delgado, an HR leader at a unionized hospital in San Jose, receives a request from union reps for extended bargaining sessions during off hours. What is the most appropriate legal and strategic response? A. Refuse, citing standard work hours and logistical limits. B. Grant the request has a mandatory bargaining obligation under California law. C. Respond that the hospital has no duty to accommodate off-hours requests. D. Agree only if the union pays for management's overtime. Answer. Correct answer. B. Explanation. Under California's Mayors-Brown Act for public employers and National Labor Relations Act (LRA) for private employers, employers must bargain in good faith, which includes reasonable accommodation of scheduling. Courts have held that refusing to adjust timing without discussion may constitute surface bargaining, a violation of labor law. Question 25. A detailed analysis of a company's 5-year workforce plan reveals mismatch between HR goals and projected regional talent supply in Northern California. What is the most strategic response? A. Outsource jobs overseas to reduce dependency on local markets. B. Hire based on availability rather than skills to fill gaps. C. Align workforce planning with labor, market data, and talent pipeline development. D. Rely on referrals from current staff to reduce search efforts. Answer. Correct answer. C. Explanation. California's dynamic labor market requires HR to plan based on local workforce trends, regional talent shortages, and demographic shifts. Strategic alignment with labor market analysis, using data from Employment Development Department or state workforce boards, ensures sustainability and competitiveness. Quick fixes often compromise quality and compliance. Question 26. To determine whether an internal HR audit is legally sufficient, a San Francisco company includes personnel files, I-9 forms, and wage statements. What critical California-specific element must also be included? A. Employee social media profiles. B. Record of weekly lunch menu options. C. Copies of signed Wage Theft Prevention Act notices. D. Annual employee award nominations. Answer. Correct answer. C. Explanation. California's Wage Theft Prevention Act, Labor Code SS.5, requires employers to provide written notices to new non-exempt hires about wages, employer info, and benefits. These signed notices are subject to audit and must be included in legal compliance reviews. Omitting them increases legal exposure, especially during DSC or Labor Commissioner audits. Question 27. A demonstrated by Ista Singh's approach to handling workplace theft at Los Angeles factory, an employee is terminated after surveillance footage shows suspected misconduct. However, the employee was never interviewed. What key mistake did HR make? A. Using surveillance footage as evidence. B. Terminating without second opinion from the EO. C. Failing to allow the employee an opportunity to respond. D. Issuing termination during union organizing period. Answer. Correct answer. C. Explanation. Even under full employment, California courts consider due process-like principles. In wrongful termination cases, employers are expected to allow the employee to explain or defend themselves, especially in misconduct claims. Skipping this step risks claims of retaliation, defamation, or wrongful discharge. Question 20. From a practical standpoint, a Santa Clara startup pays all sales employees the same base salary, but does not track their rest breaks. What potential risk does this pose under California law? A. No issue if employees sign an annual waiver. B. Risk of violating wage order provisions on break compensation. C. Only hourly workers are entitled to break periods. D. Salaried employees are exempt from any overtime or break pay issues. Answer. Correct answer. B. Explanation. California wage orders require that non-exempt employees receive paid rest periods and unpaid meal breaks, regardless of whether they are salaried or hourly. Employers must track and compensate missed breaks with a 1-hour premium per violation. Labor Code SS.7. Waivers are not valid for rest periods, and misclassification is common legal pitfall. Question 29. In the absence of a written policy, a company starts collecting biometric time clock data. Employees file complaints about privacy violations. Which of the following best reflects the employer's legal obligations under California law? A. No notice is required if the data is used internally. B. Employer must give advance notice and explain usage under ECPA. C. Employers are free to collect biometric data if it is encrypted. D. Only public entities must comply with biometric privacy rules. Answer. Correct answer. B. Explanation. The California Consumer Privacy Act (CPA) and SPHRc apply to employee data, including biometric identifiers. E.g., fingerprints. Employers must give clear notice, state the purpose, and outline data retention and security protocols. Encryption alone does not replace the obligation of transparency. Violations can trigger private rights of action. Question 30. Based on the information gathered during a recruitment campaign, is Ortega observes a significant drop in applicant diversity for a creative agency in Los Angeles. Upon review, the company's social media shows images featuring only one demographic group. What is the most strategic HR response? A. Repost the same images with new slogan. B. Focus on internal diversity before adjusting branding. C. Redesign branding to reflect inclusive workplace culture and values. D. Use stock photos to give the appearance of diversity. Answer. Correct answer. C. Explanation. California. Job seekers are highly responsive to authentic, inclusive branding. Employer marketing must accurately represent the diversity and values of the organization, or it risks alienating underrepresented applicants. Tokenism, e.g., stock photos or delays in addressing image gaps can hurt employer brand and day credibility.